यस बताइए क्या है।
लॉर्डशिप, जो डिसमिसल और टर्मिनेशन, मतलब जो वर्ड टर्मिनेशन है वो डिसमिसल नहीं है।
हाँ,
मेरा कहना है कि डिसमिसल जो होता है वो टर्मिनेशन है।
he is taking the definition of dismissal and termination from the CCA rules.
CCA. Your lordship, in that rule also, the rule 10 talks about the penalties. Penalties regarding the inquiries and everything. And what he was saying is the explanation of that penalties. The rule doesn't say that dismissal does not include termination.
नहीं, बट दोनों अलग अलग डिफाइन किया है
Your lordship, and there is one case law. The case law is Krishna Kumar Kosaria versus State of Chhattisgarh. This case is decided by the Honorable DB of this court. In that case, the scope of word dismissed and removed employed under Article 311 of the Constitution of India came up for the consideration before the Constitution Bench of Supreme Court in the matter of Motiram Dheka versus General Manager, North Eastern Frontier Railway, in which Justice Subba Rao, in his concurring yet separate opinion, has expressed that the said word means nothing more or less than the termination of the service of a person's office. The effect of dismissal or removal of one from his office is to discharge him from that office, that is to bring out cessation of service. Thus, the said words comprehend every termination of service of a government servant. Article 311(2) is an effect, therefore, lays down that before the service of government service are so terminated, he must be given a reasonable opportunity of showing cause against such a termination. Here, the word dismiss is.
Now here the position जो what I think कि different है कि आपका जो probation period था that was not over.
Your lordship, regarding this also,
यदि confirmation हो गया होता then the word used as termination or removal.
Your lordship, regarding that case, that fact also, I have another case.
What is important was the cessation of service. The phrase used is cessation of service.
The substantive meaning is cessation of service.
So cessation may be in different ways. So one is termination, as in the present case,
so
non-confirmation.
Your submission would be that there is no confirmation after the completion of probation.
And therefore, this cessation cannot be equated with the cessation of service in terms of removal or dismissal.
Your lordship, in this case of Dharam Singh, the Honorable Constitution Bench of Supreme Court has decided, that is in para 5, your lordship, kindly refer para 5.
Para 5.
It is regarding the deemed confirmation, your lordship. In the present,
वही तो बोल रहे हैं कि उसमें कोई clause नहीं है deemed confirmation का.
Your lordship, the probation period, the maximum probation period is it already expressed in that it cannot be it shall not be exceed more than 3 years. That is decided in this case only. Your lordship, in this case, rule 6, as we see in para 1, this second page, rule 6, from 5th line, rule 6. First we'll see the facts of the case. 6.1, members of the service officiating ought to be promoted against permanent post shall be on probation in the first instance for 1 year. Second, officiating service shall be reckoned as period spent on probation, but no member who has officiated in any appointment for
1 year shall be
entitled to confirm unless he is appointed against a permanent vacancy. Third, on the completion of the period of probation, the authority competent to make appointment may confirm the member of his appointment if his work or conduct during the period of probation has been in his opinion unsatisfactory, he may dispense with his service or may extend his period of probation by such period as he may deem fit or revert him to his former post if he was promoted from some lower post. Provided, here is a proviso clause is there, provided that the total period of probation including extension, if any, shall not exceed 3 years.
That precisely he wants to say कि in his appointment or if his work or conduct during the period of probation has been in the opinion unsatisfactory, he may dispense with his service or may extend his period of probation.
Yes,
Now
Lordship.
you have been dispensed with your service.
Your Lordship, I am taking a reference like the total period of probation should not exceed 3 years. Here the proviso clause says that proviso 3. In this regard, the Supreme Court said in para 5, Your Lordship, in the present case, Rule 6.3 forbid extension of the period of probation beyond 3 years. Where, as in the present case, the service rules fix a certain period of time beyond which the probationary period cannot be extended, and an employee appointed or promoted to a post on probation is allowed to continue in that post after completion of the maximum period of probation without an express order of a confirmation. He cannot be deemed to continue in that post as a probationer by implication. The reason is that such an implication is negated by the service rule forbidding extension of the probationary period beyond the maximum period fixed by it. In such a case, it is permissible to draw the inference that an employee allowed to continue in the post on completion of the maximum period of probation has been confirmed in the post by implication. In 9th para, Your Lordship, immediately upon completion of the extended period of probation on October 1st, 1960, the appointing authority could dispense with the service of the respondent if their work or conduct during the period of probation was, in the opinion of the authority, unsatisfactory. Instead of dispensing with their services on completion of the extended period of probation, the authority continued them in their post until sometime in 1963 and allowed them to draw annual increment of salary, including the increment which fell due on October 1st, 1960. The rules did not require them to pass any test or to fulfill any other condition before confirmation. There was no compelling reason for dispensing with their service and re-employing them as a temporary employees on October such and such, and the High Court rightly refused to draw the inference that they were so discharged from service and re-employed. In these circumstances, the High Court rightly held that the respondents must be deemed to have been confirmed in their post, though the appointments authority did not pass formal order of a confirmation in writing. It should be presumed to have passed order of a confirmation by so allowing them to continue in their post after October 1st, 1960. After such confirmation, the authority had no power to dispense with their service under Rule 6.3 on the ground that their work or conduct during the period of probation was unsatisfactory. It follows that on the date of impugn order, the respondent had the right to hold their post. The impugn order deprived them the right and amounted to removal from service by way of punishment. The removal from service could not be made without following the procedure laid out in the such rule and without conforming to the constitutional requirement of Article 311 of the Constitution. In my service rule also, Your Lordship, it doesn't say that any specific order of confirmation has to be passed. And it says on completion of probation.
Yes.
And there is a probation, the total period of probation that it shall not be exceed, it
3
shall
years.
not be exceed 3 years.
3 years.
So with this judgment, I am deemed confirmed, Your Lordship. And Your Lordship, non-communication of ACR during my service period is a violation of Article 14. That is decided in Devdutt also, in Sukhdev case also. Because the purpose of writing ACR,
that you have already argued.
Yes, Your
That you
Lordship.
have already argued non-communication of the ACR.
Yes, Your Lordship, and there is a recent judgment also. That's a Abhajan, state of Rajasthan. Para 71 from 4th line. The non-communication of the ACR to the appellant has been proved to be arbitrary, and since the respondent choose to hold an inquiry into appellant's alleged misconduct, the termination of his service is by way of punishment because it puts a stigma on his competence and thus affects his future career. In such a case, the appellant would be entitled to be protection of Article 311(2) of the Constitution. Moreover, the adverse comments in the ACRs for the year 2015 could not have been the basis on which the appellant was discharged from service. The appellant was never granted an opportunity to improve, and there was no intimation to him about his performance being unsatisfactory. Importantly, no verifiably complaint was filed against the appellant that could form the basis of the disciplinary proceeding against him. And your lordship, in the in recent case of Sarita Chaudhary versus High Court of MP also, as far as other material considered is concerned, it could have been the complaints, the para 1 or subclause 1, your lordship. In the subclause 1, it says that the ACR which were adverse in nature were either not communicated in time, and even after an explanation was received, there were no effort to expunge the adverse remarks made in the said ACRs on the basis of a consideration of the explanation. Possibly they were simply rejected. And third says, as far as other material considered is concerned, it could have been the complaints which were either concluded or pending against them. If the complaints form the foundation for these officers to be terminated, we find that the voluminous cases which we have referred to above in our discussion would clearly point out that an opportunity had to be given before termination. This is particularly having regard to Article 311 of the Constitution, read with relevant conduct rules. For therefore, in our view, the termination of this two judicial officer is punitive, arbitrary, and therefore illegal. They are not in accordance with the judgment of this court discussed above, as we have applied the test laid down in those judgment to the effect of the present cases while dealing the ACRs. The assessment charge and other material in light of the submission made by the learned amicus as well as learned senior counsel appearing for the respective petitioner. Your lordship, when we see in writ petition, page number 63, 61, your lordship, it says this was the note sheet regarding that put it is regarding deciding my confirmation. In page number 61, it says the assessment chart of Kumari Bhardwaj containing grade and adverse remarks, if any, and information of pending DEPE complaints, if any, along with the copy of complaints which were placed before the standing committee in its meeting held on 31st January 2017 is enclosed herewith. The updated assessment chart and present status of the DEPE complaints, if any, against Kumari Kanksha Bhardwaj is also enclosed herewith. Your lordship, I have filed an RTI that what are the documents which have been placed before the standing committee to consider my confirmation. In page number 85, your lordship, they have placed complaints also. Your lordship, when you see preliminary inquiry 0, complaint pending 0, departmental inquiry 0, disposed of DEP complaints 3 complaints. But these complaints were not decided by the committee, your lordship. These are pending, but it was put before the standing committee to decide my confirmation. And behind my back, they are putting everything, not deciding my complaint, but what I complained against my senior officer, they have decided that complaint only, and after deciding that complaint, they have removed me. But what complaints are made against me, they have not told me. Those complaints are not decided. And there is no complaint of any integrity or corruption or any misconduct in judicial work. There is no complaint like that. And this complaint they are taking, and they are not giving me an opportunity to present myself. That is the violation of natural right, your lordship. It's arbitrary, it's illegal, it's unconstitutional, and it's wrongful also. Because the standing committee does not have power. Still I say it does not have.
That you have already argued on.
Yes, lordship. And there is one guideline given by the Supreme Court in the case of High Court of Gujarat. versus Jayashree Chamanlal Buddhabhatti.
Para number?
Last para 38, Your Lordship.
Before we conclude.
Your Lordship. Before you conclude, we must once again reflect on the facts that have emerged in the present case. As noted earlier, the respondent was a candidate who had obtained a high rank in the selection for the judicial service and was given an independent posting in a rural area where she was living all alone. Her disposal of cases had been very good, to say the least. The complaints made by her regarding the misbehavior of the staff and the harassment to her by sections of the bar were not headed by the then district judge. Leave aside making an attempt to understand the difficulties faced by her. Instead, certain unjustified adverse remarks were made against her. Subsequently, the then district judge conducted the preliminary inquiry against her in his capacity as the vigilance officer, wherein without any justification he tried to connect her with the death of the wife of another judicial officer. It is duty of the district judge and also of the High Court to protect the judicial officers against unjustified allegations. However, what we find in the present case is that instead of doing the same, an investigation was conducted against the respondent without affording her any opportunity. Though it contained allegation against her character, and the investigation was sought to be justified as determination of her suitability for the post which she was holding. We would like to take this opportunity to emphasize that the High Court must see to it that the hostile work environment for the junior judicial officers, particularly the lady officer, is eliminated. This is necessary to encourage the young officer to put in good judicial work without fear or favor. We are constrained to say that in the present case, the High Court administration has clearly failed in this behalf. In the circumstances, we have no reason to interfere in the judgment and order of the High Court, and we confirm the same. Your Lordship, I have complained about the hostile environment in my court and everything, and they have decided that, but they have not given me any opportunity of hearing, Your Lordship. Your Lordship, because my second termination is based on my ACRs, those were not communicated to me without giving me an opportunity to represent against those ACRs, and there was no opportunity against 311 also, and I am a deemed confirmed employee according to this Dharam Singh case. So on all this ground, I want to conclude it because now I am unemployed. So Dipali Gundu Sarva case versus Kranti Junior. In that case, the Supreme Court in para 38, Your Lordship, para 38.1, it says in cases of wrongful termination of service,
back wages. You are claiming back wages.
Yes, Lord Lordship.
Yes.
Yes, Your Lordship. These are my summary.
Yes, Mr. Do you want to add anything?
Only just to clarify 2-3 things. The dates would be necessary and important. Few dates. Few dates. I'll just give 2-3 dates. The first date of appointment of the petitioner, 12/12/2013. 12/12/2013.
Appointment.
Then, Lord, the extension of probation. This was on 18/3/2016.
18/3/2016.
Now, if Lord may have a look at the order of extension, Lord, this is at page number 42, annexure P10. First, the order of appointment, Lord, I'm sorry, page number 32. So, this is only to address on deemed confirmation, Lord.
2 years or till further orders.
2 years or till further orders. Then, my Lord, comes page 42. Page 42, Lord. The period of probation of the following probationary civil judges of the lower judicial service as specified in column number 2 of the table below is hereby extended.
So 27/12/2013.
27/12/2013 was the initial date of appointment.
अच्छा.
ये ऑर्डर पास हुआ है 16 में, 18 मार्च 16.
नहीं तो up to what period his probation was extended?
Therefore, my lord, I refer to this initial order of page 32 until further orders. So this entire argument with regard to deemed confirmation.
ये what is the handwritten part?
ये इन्होंने लिखा हुआ.
अच्छा.
So I think she would have made certain notes, मतलब.
अच्छा.
तो वो while photocopying.
Hereby extended. Is hereby extended.
Is
There
extended.
is no limitation.
There is reason being, my lord, because the authorities were conscious of the fact that there cannot be any deemed confirmation, and this was never challenged by her. Then comes the order of termination, my lord. The first order of termination. 9/2/2017. This is at page number 43, annexure P11.
First order of termination.
First order of termination. Last line was hereby terminates the services. Terminates the services of the above mentioned so and so with immediate effect. So the services were terminated on 9/2/2017. Then comes, my lord, her reappointment. Her reappointment, my lord, this is page number 49. This is 28th of November 2024. 28th of November 2024. Followed by, my lord, her posting order on 3rd of December. And then immediately thereafter, my lord, on 14/1/2025, the second order of termination, page 30. So it is not one of those cases, my lord, a sort of picture is being portrayed as if she had been continuously working for ages. And therefore the concept of deemed confirmation. Now I'll submit, my lord, in fact, that concept...
Had it not been that immediately after completion of 3 years, that is on 11/12/2016, she deemed to be confirmed.
Cannot be, my lord, because the order itself said that it is still further orders, or otherwise the rule says that till she successfully concludes and completes a probation period.
नहीं, वो जो एक आया था कि not more than 3 years.
Not more than 3 years. Not more than 3 years.
So is it not more than 3 years?
It is. It is.
Then
therefore, my lord, this not more than 3 years, not more than the period of 3 years, this will have to be read, my lord, along with sub-rule 5. Sub-rule 5 is 11(5). On successfully completion of the probation, a probationer shall be confirmed in the service or post. So that element of subjective satisfaction of the employer, it's a judicial services. So it is not just that simply an officer has to pass the time. There has to be a conscious application of mind by the authorities, my lord, and an order of confirmation has to come. So unless and until that order of successful completion of the period of probation. So my respectful submission, my lord, the entire timeline would also show, my lord, it is not one of those cases where an employee kept on working for length of period. No, it is not that case. It was extended. Immediately after extension, a decision was taken not to continue. What happened to your not to continue? Did you challenge? You did not challenge. The extension that it is beyond, it is getting beyond, you did not. When that first order was passed, if that argument is taken, that first order was also beyond that period of 3 years then. Because it was in January 17.
Now, what is the development after first order was passed?
After
only issuance, you have reinstated her?
Yes.
And within a month,
yes,
you have terminated?
Yes, because it was on technical ground that the order was set aside and liberty was granted. So they had to revisit it, the entire thing. So when they revisited the whole thing, a decision was taken not to confirm. Then, my lord, this issue was raised because the challenge was in Burman case also identical challenge.
But at that time the rules was not amended.
After,
No?
after that.
After that the rules was amended.
Yes, well, that amendment is with regard to the committee, the standing committee. He also raised an argument of deemed confirmation. Mr. Burman also raised an argument of deemed confirmation in the second round. After he was terminated in the second order, in 2023 he preferred writ petition.
But now after amendment.
वो amendment तो उसका हुआ सर, वो जो standing committee. The amendment is not into the service rules. वो standing committee में high court rules. So his challenge was also on similar lines that since my period of probation is already over, 3 years is over, I also stand to be deemed confirmed. So the court said that no, this order stands confirmed, my lord, in the writ appeal also. So these are the two orders, my lord. The Honorable Single Judge, my lord, he had framed an issue, point number 2, at flag date note, para 9. Whether in absence of any certificate, my lord, fine.
Yes.
Whether in absence of any certificate issued by the competent authority regarding confirmation of the petitioner will be deemed to be confirmed on the post of judicial officer on the count of reinstatement order passed by the High Court. Now this was answered, my lord, at para 12. Para 13. After quoting the relevant provision, lord, from perusal, lord, from perusal of the aforesaid rules governing the field, it is quite vivid that unless and until the certificate of the confirmation is issued by the competent authority, the judicial officer will remain as probationer, only as there is no provision for auto confirmation. It is well settled position of law that object of placing an employee on probation and then goes further. This observation was then tested in writ.
There should be a specific order.
Now, this was tested in writ appeal as well. Writ appeal order also, Lord, I supplied. The issue was referred to at para 10, internal page 6. The same observations of the Honorable Single Judge, my lord, was referred to. The outcome of this, my lord, was reproduced in para 12. And then, Lord, the last line of para 12, thus the point number 2 is answered against the petitioner.
Yes. Yes.
And as far as the communication of the ACR, my lord, 2017 itself, it was with her. It was duly communicated. There was no representation. Her argument is, since I was out of service, there was no opportunity for me or no occasion for me to have challenged it. But once the order of reinstatement was issued, she had that opportunity, my lord, because she knew that the ACR, the past record of the ACR is already there. So she could have moved an application. She did not. Until date, my lord, there is no representation as far as those ACRs are concerned. That is.
Your Lordship, two more things I want to
हो गया मैडम, अब कितना फिर एक के बाद एक करते रहेंगे आप तो ऐसे ही में.
Your Lordship, the rule he was telling is the with regard to Burman case is the higher judicial services rule, Your Lordship, and there the total period of probation is 4 years, Lordship.
Burman's case.
Burman's case. That rule says 4 years probation period is there, and he has completed 3 years, Your Lordship.
Yes. लिखिए मिस्टर आकांक्षा भारद्वाज इट्स में हाँ तो खैर स्टैंडिंग कमेटी तो इनकी है ना मिस आकांक्षा भारद्वाज petitioner in person, Mr.
Your Lordship,
Suyasdhar
written
Badgaiya,
synopsis.
एक मिनट, Mr. Suyasdhar Badgaiya, Deputy Government Advocate for Respondent number 1, Mr. Amrito Das, and counsel appearing for respondent number 2. Arguments concluded. Reserved for order. Yes, क्या बोल रही थी?